Thank you so much for joining us for a very lively afternoon. We are 3 hours removed from the oral arguments in the big Trump tariffs case, one of the most anticipated Supreme Court cases of the term already, and it's only November. And I would say for some of us who've been studying AIPA for the last 20 years of our lives, because I never thought the Supreme Court was ever going to weigh in on it, and it's pretty exciting and interesting. We are thrilled to have completely raided the Georgetown Law Intellectual Trust for purposes of this particular live stream to talk about the oral argument. We, of course, have for the second time in a week, no less, law professor Marty Lederman, who is our Supreme Court maven. We have law professor Kathleen Claussen, who is our economic law, international economic law maven, and Peter Harrell, who is also our economic law maven, now a visiting scholar at Georgetown Law, and also importantly, perhaps most importantly, a contributing editor at Lawfare. Thank you, all three of you, for joining us today to talk over this important case. There's a lot to get into. It was a long oral argument. It was a detailed oral argument. It was nitty and gritty. But let's start with kind of a top line thoughts. I'm going to go to Peter first and Kathleen, then Marty, because that's the order in which I got you to agree to come on the podcast with us. So Peter, let me start with you. Talk to me about your top line impression. Where did you come away from feeling about where the court is on this particular issue, to the extent you can tell, because sometimes it's hard to tell from these oral arguments?
Yeah, with that big caveat that, we are all reading tea leaves from the questions justices ask, and that doesn't necessarily indicate where a justice will ultimately come down. What struck me was that even a couple of the conservative justices seemed skeptical that AIPA, this 1977 emergency powers statute, authorizes tariffs on the scale that Trump has in fact imposed. Now, that's not to say that all of the conservatives agree AIPA authorizes no tariffs. You could see Alito, you could see Comey Barrett to some degree, sort of grappling with, well, might there be some circumstances in which AIPA authorizes tariffs in a real emergency, or where there'd be some discrete goal that the president is trying to achieve. But I do think you also heard, again, even from some of the conservative justices, a fair amount of skepticism about the breadth of the government's assertion of the extent to which the statute authorizes the kind of sweeping tariffs that Trump has in fact imposed. So I would say if you were John Sauer, the Solicitor General, arguing this case for the government, I actually think you did a pretty good job. You have a tough hand. I think you did a decent job arguing it, but I think you're walking out of that room going over to Jamison Greer, the U.S. Trade Rep, and saying, maybe it's time to have a couple of the attorneys work on our fallback plan in case we don't prevail in this case, or at least in case we don't prevail on all of the things that we would like to see upheld in this case.
Kathleen, does that sound about right to you? Do you come out with the same impression, or are you maybe a little more skeptical?
Maybe we agree on some certain parts of that. I mean, first of all, I'm pretty sure that they're already working on the backup plan. And in fact, we might see the backup plan come into play even before the decision comes out. So let's see how that comes together. But no, I mean, I think anyone who listened, right, you really come away with the impression that the government is in trouble, and that there's at least there are at least 5 votes, potentially more, that lean towards saying that the tariffs are unlawful under AIPA. That said, I think there are some interesting theories out there as to how the government could still win the case, depending on how some of the, I think again, conservative justices, and this is where I agree with Peter, how they really want to cut this, right? That there's still a pathway. There's a pathway according to which the government could still win, despite what sound, especially if you only heard the first hour. If you heard the first hour, you really thought that this was a case where the government would be in trouble. But then I think the details really came out as the questioning went on with the latter advocates, as they got into the details really about where's the limiting principle, right? If the government loses, where is the limiting principle as to where some of these statutory lines should be drawn, or even the constitutional lines. But we can get back into that in more detail.
Awesome. How about you, Marty? Where did you come away with this on?
So I came into this, I think, well, first of all, you said you've got the complete Georgetown. Hardly.
Almost.
Jennifer Hillman, we have Steve Vladeck. We have virtually half of our faculty. Just a plug for Georgetown Law Center. I went in thinking this was among the harder cases to predict that I can recollect. I usually have a pretty good sense, sometimes wrong sense, about where the court's going to go. And on this one, I thought a couple of things. I thought they would, as Peter and Kathleen have suggested, that the justices would be very uneasy about the way that the president has exercised this AIPA authority. On the one hand, that they will think that he's exploiting AIPA for purposes that are sort of external to AIPA, perhaps, and have some doubts. Maybe some of the justices might have doubts about whether his assessment that the trade deficits have caused unusual and extraordinary harms to national security and foreign affairs is a pretextual or a real finding, but one that the judiciary isn't terribly likely to get into. And so they're uneasy about it. On the other hand, many of them have served in the executive branch, and most of them are very familiar with AIPA and all of the various ways, apart from tariffs, that this statute has been implemented by presidents of both parties for all sorts of different, very compelling foreign affairs and national security related reasons. And I think they are, like as Kathleen and Peter suggested, they're very uneasy about a holding. The top level holding would be AIPA's reference to regulating importation of goods with foreign interests. Simply doesn't provide any tariff power at all. The implications of that are, concerning when you think about another president who might use it in a more responsible way, or a more tailored way, I would say. And so I want to draw the distinction here between the universal tariffs that are being applied here, the so-called reciprocal tariffs on the one hand, and the fentanyl-based ones on the other. I think the way the justices see it, and this finally came to the fore when Neil Katyal was arguing, was, well, what about all of the hypos in which there truly is an international emergency? Another nation is holding Americans hostage, is threatening to go to war. Do you think Congress would have meant to deny the president the power to use tariffs as one tool in the toolbox to try to influence or induce that foreign nation to not harm us in that way? You'd think that Congress would want to give the president that power. But this open-ended, basically, you can supersede and go beyond all of the extraordinary statutory metes and bounds and limits and preconditions that Congress has imposed on tariffs over the years. To use AIPA to do that is to blow up the entire tariff regime that Congress has pretty zealously tried to craft on its own over the years. And so I wouldn't be surprised if some of the justices are looking for a way this might fall on the line between the reciprocal tariffs and the fentanyl tariffs, or at least a holding that allows for some tariffs in some certain circumstances. But then the holding can't be that the word regulate simply doesn't include the power to impose tariffs. It would have to be something different from that, or a variation on that. The most obvious candidate for that is to rely on the superseding effect of Section 122 of the 1974 Trade Act, which got a little bit of play in the oral argument here, quite a bit more in the briefing. I can imagine that outcome. That said, I do think there's clearly at least 4 votes for saying AIPA does not authorize the broad reciprocal tariffs here that the president has imposed. And there's at least 3 or 4 other justices who are very much in play on that question, if not all 9. But so I think the odds are that they will find some way to at least declare unauthorized by AIPA the reciprocal tariffs. The fentanyl-based tariffs, I think, are a closer call, possibly, but they would need a theory that draws a distinction between the two.
That is super
Let me
useful.
just pick up on
Please,
that
Peter.
For a second. It was fascinating. I think towards the end of the argument, and it's fascinating to think about the counterfactual, because of course the case that is being litigated is a case involving the most sweeping of Trump's tariffs, right? But it's interesting to think about like the counterfactual of what if Trump had started small and gotten some favorable precedent and then built from there. And I was struck by, towards the end of the argument, Justice Kavanaugh brought up not the fentanyl tariffs, but he brought up the tariffs on India over India's purchases of Russian oil. And of course, that is the kind of thing, the idea of putting pressure on a country for buying Russian or Iranian oil is something like AIPA has been used for decades in the sanctions context. And I could have seen a scenario where, like, if that was the first case that had come up in front of the court, you might actually have had a quite different argument today. But what they have to deal with is the fact Trump is, in fact, using this statute in this incredibly broad, almost unbounded manner.
So I think that's incredibly useful context and boils down. I want to get a little bit into the nitty gritty for people who may not have been able to sit through all, 2.5 hours of argument that we got today, which is long. It's a longer, but not the longest one on record, but a long one to listen to, but pretty lively, I would say. The big focus of the argument.
The argument of McCulloch versus Maryland went for 8 days, so we're not
not anywhere close to the record. Fair enough. But I didn't have to listen to that in my sweltering hot office, so it's a little bit of a different game. So the big focus, I think, the thing we saw the most time really was the statutory text, right? We had several justices time and time again use that old phrase, we start with the plain language and come back to that. And that language there is, I think I'm capturing the key elements of here from AIPA. Does the language, by means of instructions, licenses, or otherwise regulate importation or exportation, include the authority to impose tariffs, right? The first hour that Kathleen noted, I would say it seemed like we saw very skeptical takes of the government's argument that somewhat unambiguously includes tariffs, that regulating importation has to mean tariffs. And we saw pushback there from Roberts and Barrett, two justices that we are assuming are kind of in the swing category that could determine the outcome here. But then in that second hour, we saw pushback against the plaintiffs' also categorical arguments that no, actually, for AIPA to give authority over anything revenue generating, like tariffs, it would have to be much more express or explicit. And of course, while we saw a lot of talk about the text, there is a deep, rich legislative history element of this about what Congress is trying to do with AIPA. That was raised by a couple of justices, but really didn't get too much attention. Although I will say 2 amicus briefs got name checked, one by Aditya Bumzai and another one by Paul Stephen and Andrew Kent. The latter one, I should say, there's a piece on Lawfare that brings up a lot of the same arguments and previews that folks can check out if they're interested. Both of those deal with this complicated history about what was AIPA trying to accomplish in terms of seizing assets or extracting value for the government in this sort of context. So Kathleen, let me start with you on this, if that's okay. Talk to me a little bit about where you think the justices are on this textual question, how hard a question this is. Because in a lot of ways, this is a necessary precondition, because if the text is unambiguous, you don't get to the major questions doctrine. You might still get to the non-delegation doctrine question, but you don't necessarily get to the major questions doctrine. So if it's truly unambiguous. So, where are the courts going to fall on this? Where do the justices seem to be leaning?
If I could read those tea leaves, Scott, definitely would be paid more. But I'll be very curious, Marty and Peter, your answers to the same question, because it struck me that at times, you said that you don't sort of get to those other issues. At times, there seemed to be a bit of almost an overlap, right? We weren't really clear how we were having this statutory conversation in under the shadow of the major questions doctrine, or were we having it sort of straight up if there had been no major questions doctrine. But I think you were right to flag the opening hour. Again, for me, this case for so long has been about framing, right? And it continues to be about framing, and you could see this right out of the gate with the government's repeated refrain that these are regulatory tariffs, not revenue tariffs, and to try and parse the language and emphasize that regulate can be, there's a certain type of tariff that is a regulatory tariff in the first place, and there's another type that's a revenue focused one. I think that became a fairly difficult line for him to walk, and that skepticism continued throughout both hours. But I understood in a sense sort of what he was getting at, of course, right? He wants to grab onto that language and talk about the deterrent effect that these would have. Right? He came back to that in the rebuttal a little bit better, the behavior shaping effect that these could have. And so trying to give the justices, I think, a way to say, yes, regulate, but we can work with regulate and not implicate all those tax concerns, right, that Neil Katyal led with, right, rightly so from his side, in his part of the argument. So So yeah, there's a lot more I think to be said here, and again, let's hear from Peter and Marty. But just to really take advantage of the framing and to use that as the foundation for the statutory interpretation pieces that would follow. Maybe the last thing I'll just add here is this emphasis on the Algonquin case, which for those who are not living and breathing this, right, this is a case that deals with Section 232 of the Trade Expansion Act of 1962. And that's important because that language is a little different, but the key part is it doesn't say regulate and by way of tariffs, it doesn't say tariff, it says adjust the imports. And 232, there's been no dispute since Algonquin, and Algonquin reinforces this, that could mean put tariff on. So if adjust the imports can mean that, right, then the logic follows, right, then this likewise could mean that. And I was just surprised at how much we got into Algonquin and how much that turned out to be sort of a leading point in the statutory interpretation conversation that the justices wanted to have. So let me start there. Let's see what the guys would say.
Peter, Marty, any thoughts to add on top of that?
I'll add just a couple of thoughts. I was also struck by how much Algonquin came up. I mean, I sort of see why, because one of the arguments in the issue, both the parties and many of the amicus filings made is that whenever Congress has given the president the authority to impose tariffs, it's done so expressly using words duty or tariff or excise or levy or some such thing. The one notable exception to that is Section 232, which is part of an act that very clearly authorizes tariffs, right? It's part of the Trade Expansion Act of 1962, or part of an act that very clearly deals with tariffs. But the operative provision of 232 that Trump currently relies on for his steel and aluminum tariffs, that he currently relies on for his car tariffs, is this power to adjust import. So that is the if you are trying to make the statutory argument from the government side, or if you're trying to grapple with the statutory argument as a justice, you do have this, almost every tariff statute expressly uses a word. The one that doesn't is Section 232. And so you think, well, maybe that's how we read regulate dot. Let's be clear. The statute doesn't actually say regulate importation. It says regulate, prevent, prohibit, a whole bunch of other words, importation or exportation, right? But
I didn't pronounce all the dots in between
words, to regulate importation. You got to grapple with how that might mean tariff, and Algonquin is your kind of closest textualist parallel.
Marty, I want to come to you on this too, but let me complicate this, because while Algonquin was an unexpected dog to bark and join the cacophony of this case, another dog that didn't bark as loudly as I thought it might was the Yoshida case. It definitely came up. It definitely was raised, but it didn't, at least in my mind, get quite the focus of everyone that I think I expected from the lower courts and from the briefing coming into it as an example of something that really led into how AIPA should be interpreted. I didn't hear that many justices buy into it. Kavanaugh was very direct, saying, look, Yoshida is a precedent of the same language that matters. And yes, this language was brought in, but it didn't seem to get as much play or as much engagement from the justices. Is that a sign of the strength of the argument or the weakness of that argument?
So I think it was principally Justice Kavanaugh who cared about both Yoshida and Algonquin. He is very, he is very concerned about precedent usually, and wanting to reconcile what the court does with what he thinks is a fair view of what the court has done in the past and what Congress has done in the past. Yoshida, for those of our viewers who don't know, was not a Supreme Court case. It was a Court of Appeals case, but it occurred very shortly before AIPA was enacted, and it involved similar language, in fact, virtually the same language in the Trading with the Enemies Act, before that was amended in 1977. And the Court of Appeals held, on the one hand, they construed the words regulate importation of foreign goods to include the possible imposition of tariffs. But on the other hand, in an important footnote, said that Congress had subsequently really addressed this kind of problem, the problem that is raised, at least in theory, by the so-called reciprocal tariffs, balance of trade, balance of payment problems in Section 122 of the 1974 Act. And the challengers' view, and I think it's a strong one, is that the government can't really rely on the theory. The government downplayed, they put it in their brief, but you're right, Scott, that they downplayed this argument that the 1977 Congress ratified or embraced the Yoshida decision. They still want to make something of it. Hey, a court of appeals said regulate includes tariffs. But you have to take the bitter with the sweet. They also said that when it comes to these kinds of tariffs going forward, Congress has now specified the metes and bounds of those tariffs in Section 122. And so I think, if anything, it's fair to say that the 1977 Congress probably thought that the issue was mostly resolved by the 74 Trade Act, right? That kind of addressed more specifically what Nixon had done in that kind of problem. It was not, so I don't, it's not getting a lot of play for that reason. I don't think Algonquin's going to get a lot of play. It was a unanimous decision. It was a pretty uncontroversial. I just think that's Justice Kavanaugh for the most part. I will say, though, that I don't think the justices were very skeptical of the what I'll call the top line argument, which is that just looking at the text, the absence of the word tax, impose a duty, impose tariffs, in conjunction with all these other verbs and nouns, as Justice Barrett pointed out, and the nouns that are in there, is in and of itself determinative, right? Like if this were a more modest case brought by our counterfactual president who's dealing with an exigency Congress could not have anticipated, where a tariff might really address an emergency in a discrete way, I think they probably have no problem, maybe all 9 of them, saying that the word regulate encompasses the imposition of tariffs. And the plaintiffs, to their credit, Neil Katyal did not, he went out of his way 3 or 4 times to say, our argument is not that you can just look at the text and that determines it. He wanted to broaden the focus, and I think this was the right strategy, and I think it's also correct as a matter of just discerning Congress's design. He said, look, this is the one area, imposition of tariffs, in contrast to all these other things, prohibitions, quarantines, quotas, all these other powers that are given to the president in AIPA, those are not nearly as comprehensively covered by other statutes, and so you'd want to give them those powers in an emergency situation. By contrast, Congress is all over the question of tariffs and has been very particular about passing a lot of laws that are meant to deal with exactly the problems at issue here. For whatever reason, they have been zealous about keeping that control over what the executive does when it comes to assessing tariffs for reasons that are both historical and institutional. And I think there's a lot of different stories to be told about why that is. And so Neil Katyal's focus was, you can't look at AIPA in isolation. You have to look at it as part of a corpus of laws in which Congress has a very highly reticulated scheme of when tariffs can be imposed, under what conditions, for what times, against whom, for what purposes, et cetera, and looked at in that broader statutory focus. That was definitely the strength of his argument, I think, and I think it resonated with most of the justices. So it won't be determined on the plain text of AIPA, nor do I think the major questions doctrine. The major questions doctrine might appear in the opinion, but I don't think it's what's going to influence what the justices are doing.
Well, interesting. That leads right to the next topic I want to talk about, which is the major questions doctrine, which I would argue probably got the second most focus after the textual arguments and the context and legislative history of AIPA. I mean, at one point, you had Justice Gorsuch, actually at 2 different points, really almost try and bludgeon the plaintiffs into conceding that they needed the major question doctrine to win their argument. And in the case of the Counsel for Oregon, actually did succeed. He basically conceded at the end after Neil Katyal wouldn't for the small business plaintiffs. Let me come to you on this, Peter, in the first instance, although Marty and Kathleen, I also want to get your views. Talk to us about what you saw in the major question doctrine here. I mean, if major question doctrine seems clearly implicated, at least by the global tariffs, because it is such a massive social economic question, you would then say, okay, this doctrine that this court particularly has developed in the last few years says if something is of this big magnitude, we need to look with extra scrutiny to confirm that Congress intended to confer this authority. And that would mean that if you have an ambiguous statute, which maybe is the median outcome of the statutory analysis, then that's a problem for the government. But did you see a critical mass of justices buying into this? I mean, it seemed to me that you saw Chief Justice Roberts, Justice Barrett all hinting at it and emphasizing the ambiguity of the statute. But it really was Gorsuch that really seemed to hit it most squarely on its head. Kagan mentioned it once or twice. What role do you think that was playing here? Marty, then I want to hear from you about why you think it's unlikely to play a central role.
Yeah, so the major questions doctrine has, been an issue as these consolidated cases have wound their way through the court system, and I was not at all surprised that we had a fair amount of discussion of the major questions doctrine here. The government, and you heard this with Sauer today, has sort of two arguments for why the major questions doctrine shouldn't apply. The first of which they're not pressing that hard on, which is that it doesn't apply to presidential action. It only applies to agency action. I think you saw the Federal Circuit deal with that. You did not see Sauer really pushing that argument here. But in his entire framing of the case, he is arguing that the government has been arguing, this is really a foreign affairs issue, and the major questions doctrine doesn't apply in matters of foreign affairs. And you did see this come up throughout the debate. The counter argument there, which also came up quite a bit, is that it may or may not be true, and I defer to Kathleen on this, whether the president has inherent powers in the realm of foreign affairs or not. Well, that may or may not be true. Certainly the court believes that to be true. It is kind of almost equally indisputable that at least in peacetime, the president does not have any inherent authority to impose taxes or tariffs. That is entirely a congressional prerogative. So, if the more you think of this as a case that is about taxation, the more you logically would view the major questions doctrine as applying, and the more you think of this as a foreign affairs case in the government's view, the more you can argue that the major questions doctrine doesn't apply. And I think you saw that tension playing out, throughout both the justice's question, throughout Sauer's arguments, and throughout both Katyal's arguments, and also throughout the Mr. Gutman, the Oregon Solicitor General's arguments.
So, and this question, the major question doctrine, strikes me as particularly relevant because it seems like the clearest way that you're going to hit that split potentially between the reciprocal or global tariffs and the fentanyl / trafficking tariffs, whatever you want to call them, because they are of different orders of magnitude. So, Marty, I'm kind of curious about why you don't think the MQD is likely to come in here, particularly if you see the intuitive appeal on the kind of broader equity / political factors / assorted ephemera of that split. Why you don't see the MQD playing that role? Because that's how that's how I've always thought of it. But I'm curious if maybe there's other ways to arrive there, or if maybe that's giving it too much centrality.
So as I said, I wouldn't be surprised at all if a lead opinion invokes the major questions doctrine. But I don't think that's what really moves the justices. They just made that doctrine up out of thin air a few years ago. And it's what's really getting at. And to her credit, I don't agree with a lot of Justice Barrett's separate concurrence in the student loan case, Nebraska versus Biden. But she's being sort of thoughtful about what's going on here, which is what should our presumption be about what Congress is up to? And yes, we should be more skeptical that they're giving away the store to the executive than giving away tiny little things to the executive, right? Like the Congress would be more hesitant about doing the former than the latter. This is obviously a very big store. On the other hand, they all think and they do know. So it's a major question. There's no doubt about that. But so are all AIPA questions, right? They're all major. And then the question becomes, okay, fine, it's a major question, but they're not going to issue an opinion that calls into question, because of MQD, any of these other authorities that might be implicit in AIPA that have been exercised for many years. Some of them you could say it's just unambiguous. It's a major question and it's clear Congress delegated it to the president. So that answers the major question, yes. But others are going to be much more ambiguous, I think. Kathleen knows much more about the statute than I do, I think. And therefore, what I think they'll be concerned about is that major questions analysis, and certainly non-delegation analysis, which I do not think is going to play a role, the implications for the rest of the AIPA authorities is going to be something they're very, very focused on. And that is why I think that the more straightforward way to decide the opinion, and what's actually going to drive them, regardless of what the opinion says, is what did Congress intend here when you look at their everything that they've done in this area, including the 74 Trade Act and other statutes? And the answer to that is maybe they did intend to give the president some tariff authority for true unforeseeable exigencies that are much more discrete. But when it comes to the reciprocal tariffs, kind of Congress figured out what they want to do with that. And it's in the statute, and President Trump's just trying to circumvent the decisions Congress has already made. I don't know whether that writes, but that would seem to me that might take the form of an MQD opinion, but I think it's more about what is it reasonable to assume Congress was doing here.
Interesting.
Scott, I think that listening to Peter and Marty and only reinforced my feeling at the end of the argument earlier today that MQD is kind of the wild card still here, right? It's just we just don't know how they're going to work with it, and nothing about what they said in their back and forth earlier today I thought was a particularly guiding light to help us answer how that was going to go.
Fair. That's useful. Kathleen, I know, has to step away briefly, although she may be able to rejoin us. So we'll let Kathleen do that. But Marty, let me come to you on the other doctrine you just mentioned about not playing a role in this analysis. And that is the non-delegation doctrine. Something that was front and center of some of certainly the early briefing and some of the legal challenges of this has been front and center in a number of the other legal challenges to some of the AIPA-based tariffs the president has put forward that haven't risen all the way to the court. This idea that AIPA itself does not give enough of an intelligible principle for Congress to delegate this huge swath of authority that it has given to Congress through AIPA, including this tariff authority, or perhaps most specifically this tariff authority. Talk to us about why you don't see that playing much role, because I think you're right. It really didn't come up too centrally in the argument, a couple of spots here and there, but it never really got a lot of emphasis and never really got a lot of debate going between the justices, which I take as an indicator as to how seriously it's likely to play and how they're thinking about this case. I'm curious about your thoughts about that.
So this is actually pretty simple. I've never thought it's going to drive the case because a non-delegation doctrine holding is basically a holding that AIPA is unconstitutional because it is delegated far more, or at least equally as significant powers to the president in ways that are not very judicially reviewable. Let's put it that way. Even if there are nominal limits on what's an emergency, what do you have to demonstrate to show that a threat is extraordinary and unusual and the like. The courts are not going to be very eager to get involved in assessing those decisions, and therefore Congress has offered extraordinarily unbounded delegations in this area to the president, and I don't think there's a justice on the court except possibly Gorsuch who is going to be troubled by that. And it's very hard for me to see why you'd say that including tariffs makes it unconstitutional, but everything else is constitutional. I just don't see that happening.
Fair point. Peter, you have any thoughts on top of that? Please.
So I agree. I don't think that the major questions doctrine is going to play a particularly significant role in this decision. But I actually, one of the things Marty said, and I agree with Marty that I can see a scenario in which the court tries to, draw a line here where AIPA doesn't authorize the reciprocal and universal tariffs, but maybe does authorize the geopolitical tariffs, if you will. I think very practically, the challenge that we as a country will see with that, if the court goes down this road, is that we have a president who will not hesitate, if that is his legal authority, legal right to do, to come up with pretextual reasons to reimpose all or substantially all of these tariffs just not for the trade deficit, right? We will discover he cannot impose a tariff on the European Union of 15% to deal with the trade deficit, but Emmanuel Macron offended him, and the fact he is offended is a national emergency that authorizes a 15% tariff on the European Union. And so I do think
I don't know, Peter,
because it is going
to that wouldn't be extraordinary and unusual, though.
but you see, I don't think the court's going to want to review like what is and what is not extraordinary and unusual here. And like maybe if he's only a little bit offended, it's not extraordinary and unusual. But if he's very offended, it is. Like I just think this is going to be a very hard set of line drawing for the court.
Well, Peter, that leads actually perfectly into the next set of questions, which are the dogs that didn't bark, or at least not very loudly here. And there's kind of two interrelated ones that you've written about for us at Lawfare. You and I have talked about in some of our prior podcasts and conversations about in this case. And that is the relationship to the emergency nature of the authority and the kind of two nexus of that. One is the question of the declaration of emergency itself, the reviewability of it. We had a little bit of a soliloquy on that back and forth about how judicially reviewable is it. You had, I believe it was Sauer, say, well, there's procedural elements that are reviewable, but the core substance of the determination that this was an emergency is the part that's not reviewable in the eye of the executive branch. Then you have the separate question of, okay, assuming there is an emergency that has been declared, reviewable or not, to what extent are the relationship between that emergency and the actions being applied something that's reviewable? For example, if it's pure pretext and the actions don't have much correlation, something that was essentially put forward in regards to particularly the fentanyl tariffs, I believe by counsel from Oregon. Oh, I could be wrong. It may have been Kathleen as well. So talk about why I did not see these come up very prominently here. They've been a big talk of, I think, the AIPA nerd conversation, in part because those questions are so foundational to AIPA. They would have broader ramifications if they were implicated. And maybe that's why they're not being brought up here. But I didn't hear them that much in this argument. Do you think that's a sign the courts just don't want to engage in this? That's not playing a central role in what they're thinking about? Why weren't these things more central to the debate?
It's very interesting you say that because, we as you say, we had almost all, maybe 80-90% of the argument was fundamentally about, does regulate importation or exportation include a tariff power, without a lot of debate at all about, are declarations of national emergency judicially reviewable? Is a determination that something is an unusual and extraordinary threat judicially reviewable? And then finally, this question of, do the tariffs deal with, because AIPA requires the act taken be to deal with the unusual and extraordinary threat, hardly came up at all. It's funny, towards the end of the argument, I think it was Justice Jackson said you wanted to talk about the deal with argument, but she even referred to it as with Mr. Gutman. He said, I want to talk some about, I think it was your secondary arguments here, right? So even the justice was sort of acknowledging all these other issues are secondary arguments. I think the reason we have not seen more debate, we did not see more debate about those arguments. Some of it may just be time, right? You start with the big questions and you run out of time. But the other one is there is quite extensive up through the federal circuit level case law that, these kind of declarations of national emergency are not judicially reviewable, that the relatedly, it's hard to review the unusual and extraordinary threat. This has been litigated quite extensively in the AIPA sanctions context, and the courts have been pretty deferential. And I think that has sort of gotten the plaintiffs in this case to not particularly heavily emphasize those arguments because they think those are uphill battles and that they are more likely to succeed on this matter of statutory construction.
So let's go on to the question about what comes next, because I think this is a big background consideration. We did hear it come up in arguments. We heard particularly Justice Barrett, somewhat ironically, given that, I think just within the last month or two, we had an opinion where she says it doesn't matter if claims brought against the federal government have to go through two separate channels and if it's completely inefficient, because that's the way Congress designed it. In spite of that view, in that case, she in this case said, well, what about all the chaos that's going to come about reimbursement? What's going to come after this if we strike down these tariffs? Isn't that a big problem? And it does open the door about what comes after this. So let's start, instead of going to the reimbursement part, which I think is important, let's start with the reimposing Trump tariffs aspect of this. I'll start with you on that, Peter, because I know you and I have talked about this before. If Trump tariffs get struck down, what are the alternatives that he has other than AIPA to bring in? Let's just assume for the time being that this is a world in which AIPA is no longer available to the president, or is impractical. It's been impractically narrowed for tariff purposes. We know 232, 301, this alphabet soup of three number authorities that deal with trade and tariffs. How big is the delta between that and what he's doing with AIPA? And what does that mean in terms of policy differential? Is it just that they're slower, that take more time to implement? Are they less agile? What will the post, VOS selections decision tariff regime look like, assuming the Trump administration is going to find some way to try and pursue it again?
So I'm happy to talk about that, but I actually do want to talk about refunds because I think
I was going to come back to that next. I wasn't skipping it.
Would necessarily be complicated, right? The fact is, from a mechanical perspective, this actually does not have to be complicated. Customs and Border Protection actually quite good IT infrastructure to process both kind of incoming estimated tariffs and also to process potential refunds of tariffs when there was some valuation change, or there are all kinds of sort of technical reasons why you might adjust your tariffs. Also, the way mechanically an importer pays tariffs, you pay a estimated tariff, and then 10, 11 months later, it's what's called liquidated, which is where it gets finalized. Like, most of the AIPA tariffs have not been liquidated or finalized yet. So actually, from a mechanical IT perspective, it would be quite simple for CBP to kind of automatically, at the liquidation stage, or when importers file their final paperwork, to simply provide a refund of the AIPA portion of the tariffs. This is actually not mechanically difficult. Now, there are questions because, like, the entity that paid the tariff might not be, like, there might be some contractual issue between that entity and another entity. But from the government's perspective, it is a myth that this has to be complicated. That is not to say that the Trump administration will not choose to make this complicated because they don't want to pay refunds. But we need to understand that is a policy choice they would be making, not that it is actually mechanically difficult or would actually have to create chaos to do refunds. But I'll give a shorter answer now for what Trump would do next. So I think there are kind of two options that he could take if he loses the tariffs. And I should posit here, one question, of course, will be whether he loses all AIPA tariffs or only some, because if he only loses some AIPA tariffs, he may try to recreate some of the trade deficit, tariffs under other pretextual justifications, right? So that would be one option for him. But if he loses all of the AIPA tariffs, I think he kind of has a choice of two things. The first thing he could do would be to invoke Section 122, the Trade Act of 1974, to impose a 15% tariff for up to 150 days and use 150 days to figure something else out for the long term. And that would probably be a combination of 301s and maybe some expanded 232s. His other option, and this came up a little bit at the oral argument, is Section 338. So this is Section 338 of the Smoot-Hawley Tariff Act. It is still maybe on the books. There's some questions that came up a little bit during oral argument about whether it has been superseded or not. There are some questions about mechanically how it would work because it has not actually been used since 1940 or 1941. But in theory, 338 could be a pretty flexible alternative basis for tariffs. But if he goes down the 338 route, he may find himself back with some major litigation against it quite quickly, which is why if I were advising USTR, not that I think they particularly want to hear from me these days, but why if I were advising USTR, I'd be like, pull your 122 trigger and then do a bunch of 301s or try to get Congress to pass some new taxes, or, something like that.
And just out of curiosity, functionally, the reason why it seems, although I don't think we 100% know why President Trump and his administration have preferred AIPA over these other authorities so far, is because of ease of implementation, ease of administration, and then flexibility. They can adapt. And we've seen the president do that, adjusting rates, adjusting targets as negotiations are ongoing, very dynamic, fits into his deliberately often mercurial, or at least described as deliberately mercurial negotiation strategy. Does that still the case under these other authorities, or is that likely to be a little bit of an impediment to the dynamics that they've pursued in these negotiations, which is this rapid adaptation to conditions in response to negotiation positions? Is that as easy to do under these other authorities?
So it's not. I mean, I think that these other authorities are, at the end of the day, could allow President Trump to recreate a substantial, though not complete, share of his tariffs. But all of them, whether it is 301 or whether it's 232, I'll come back to 338 in a minute, all of them have substantial constraints. So 122, for example, cap of 15%, right? You can't do 50 on Brazil under 122 and capped at 150 days, absent congressional action, right? So it goes poof in 5 months. Section 301, you have to do fact-finding of an unfair trade practice that the foreign country is engaged in that burdens U.S. Commerce. Now, traditionally that has been a very long and detailed and involved process. Maybe you could shorten that up some, but you do have to do the fact-finding. You would have to notice and comment adjustments in tariffs. It's a lot more process. 232, as we see, Trump is doing a bunch of 232s. He's actually gotten not that many of them out because it takes a lot of fact-finding and proves complicated. So I think at the end, if I think sort of mathematically, if we had sort of 15, if we had before Trump coming in, putting aside China, maybe 3% average U.S. tariffs, and if today we have 15% average U.S. tariffs, I bet Trump could get us to 11% average tariffs with these other authorities, but he couldn't turn them off and on. It would take him quite some time to increase them or decrease them. Even 338, you have to give 30 days, if it is lawful, you have to give 30 days notice before actually imposing the tariff. So even that, he couldn't just decide he's mad at Doug Ford, the premier of Ottawa, over a TV ad, and, I want to turn on 10% tariffs over that.
Well, and this kind of feeds into a broader question I want to take to you, Marty, as somebody who, has spent a good part of your career advising the president and the White House about the law, where it constrains them, ways they can try and pursue policy objectives consistent with the law, and the gray areas that sometimes exist in parts of the law about how to shape it. Because it strikes me there's a strategic question that kind of goes back to something actually Peter raised at the top of this, which is that, and I think you made this point, Marty, this is the case the Trump administration ran to the Supreme Court on. It is after they've implemented their global tariffs. It's the most aggressive use of this authority that one can really imagine. They did initially start with the fentanyl trafficking tariffs, right? There were a number of months where those were the tariffs on the books before we got to the reciprocal tariffs, and there were legal challenges to those. And you can imagine a world where an administration saying, we are in office for 4 years, we want to pursue tariffs aggressively, we want to vindicate this authority, how do we get to the end of this? Well, maybe we start some test cases and we try and run these up to the courts to vindicate, for example, that you can do tariffs under AIPA. And then once we have that, we're in a much stronger position to go do what we want to do in other contexts. I sometimes see elements of that kind of strategy, maybe even in things like the domestic deployments context, which you and I talked about last week, and we can circle back on that. But here, I have trouble understanding exactly how the administration arrived at where it is legally, particularly at this moment where it seems like they very well might lose on this top line policy priority. Do you have a sense of that? Is it just, the tail wagging the dog? This is not a legal strategy. This is a political strategy, and the lawyers are playing catch up as best they can, which is part of the lawyer's job. And maybe that's the way it happens. Or is there something more substantial happening here?
You're asking me to accurately describe what goes on internally in the Trump administration. My guess is
the lawyers, no less, at the Trump administration.
As good as, and probably a good deal worse than yours. There are many other people on this. Look, I think it seems to me, just as an outside observer, this is one in which Donald Trump truly believes that that his ability to, as Peter calls it, the mercurial negotiation game that he's playing with all these foreign countries will redound to the benefit of the U.S. economy in profound ways, rightly or wrongly. He truly believes that. And remember one of the most extraordinary things about this case is that the Solicitor General of the United States actually opened his brief in the Supreme Court by quoting the president to the effect of the United States was a dead country and now he has revived. It's just absolutely shocking, right, that the Solicitor General would put that in a brief of the United States, like lead with the insanity, right? And but that's what the president thinks. And so you can't wait until the second year of the administration to say, oh, now there's an emergency and we've been a dead country and I haven't been doing anything about it for 2 years. He thought, and I don't know whether he's right or wrong, that this would profoundly improve our economic condition and that his negotiating skills with foreign leaders would get us there. And I think he probably was advised that from a legal perspective, the kind of the slower rollout, the more discreet and targeted fentanyl-based or rollout that you're describing, Scott, is more likely to stand you in good stead with the courts going forward. But I don't think that's, I think this is one he really just cared about a great deal. Right? It wasn't just that he campaigned on it and wanted to put down a marker that he's doing it. There's a lot of these things in which the courts are enjoining him from doing things, and he's perfectly probably fine with that. He can tell his base, I tried, and we tried to do this, that, and the other. This is something I think this is one of the principal things he wants to do. And if I had to guess, I'd say that's what's going on here, that this is really coming from the top. This isn't the lawyering strategy.
Fair enough. Fair enough. So we are almost at time, but I don't want to leave until we give the opportunity for some parting thoughts / predictions if you're up for it. I don't think it's, tight predictions, detailed predictions aren't necessarily required, although they're welcome if anyone wants to take a stab at it. But I'm curious as to where you all think we are likely going to stand, a month from now, could be several months from now, but I think most people are expecting the Supreme Court to move relatively quickly if it can get on the same page on this in the next, few weeks or 2 months before the end of the year. Marty, you've already hinted at your sense of the takeaway on this. So talk to us about your vision about where you think this comes out, and give us a confidence interval, how strongly you feel about it.
I'm usually bad at that. So if I say something, you should basically assume the opposite is going to happen. But coming out of the argument, it strikes me that the three Democratic appointees and Justice Gorsuch seem very strongly inclined to at least want to say that AIPA does not authorize the universal, right, tariffs. I think all of the justices are wary about a holding that will affect not so much the fentanyl tariffs themselves, but the hypos that they were raising about true exigencies. Why would Congress, Justice Kavanaugh's, the laugh line of the day was Justice Kavanaugh asking the Solicitor General of Oregon, Congress has given away everything to the president here. It's given him all of these tools to adapt to emergencies, foreign affairs emergencies. Why would I know your theory is that they've given him everything but tariffs. Why would they have excluded that tool? Why would they have cut the hole out of the donut? To which his response was, no, it's a different pastry altogether, which is a nice laugh line. But then he was met immediately by just a flurry of responses from both sides of the court, including Justice Kagan. It's like, well, give me a reason why Congress would have denied this power to the president. What's wrong with it? Now, I do think there's a good story there about how the nation has historically treated taxes and how Congress has been very, very zealous, as reflected in its statutes. I know I'm being a broken record on this, but Congress, for whatever reason, has not wanted to give away everything to the president when it comes to tariffs. And rightly or wrongly, for good or ill, it thinks it's more important that it have some control over those things. I don't know how that writes, but I can imagine them just being a little bit wary of a holding that says AIPA doesn't authorize the imposition of any tariffs whatsoever. Maybe that's the easiest way to write it, and they're comfortable. Look, presidents have not used AIPA for this before. The world has not come to an end. We weren't a dead country. It's like we haven't died. It's fine. It gives him plenty of other tools. Plus, he has a bunch of tariff authorities that Peter's gone over for the last 20 minutes. That has been sufficient till today. It'll be sufficient till tomorrow. And if it's not, Congress will give him more. That's a possibility. But another possibility is they might be looking for some sort of interim holding. And the one thing that occurs to me is this 122 use of 122 to draw the distinction. I don't know whether that flies or not, and whether that does the trick. So I think 2/3 likelihood that the universal tariffs, the reciprocal tariffs, are declared to be not authorized by AIPA, reserving whether he could do some of them through other authorities. And on the fentanyl tariffs, I just don't know. I just don't know at all. I don't have a strong sense of where they are on that.
Fair. Kathleen, what are your thoughts? Thank you for rejoining us as well, briefly catching us at the end here, but I'm glad we get to hear your parting thoughts.
Oh gosh, well, I'm sorry that I had to step out because I came in at the tail end of Peter saying we could get back some of these tariffs, but maybe not. Was it 90% is what you usually go with, Peter? Peter knows that my feeling is we can get clearly 100%. We can get there very quickly. So more on that later. But no, I mean, it's always good to come after Marty because he says things much better than I could, and I think I agree with him to a large degree on the main things you're sort of looking for here are how does it write, as Marty said, and what's the easier path versus the harder path, and which one of those would they take, particularly, I think, informed by the hypotheticals that were raised by various of the justices. But I do come back also to where I started our conversation, Sky, with respect to the what's the limiting principle, right? That argument that really captivated the attention of those justices who I think are the wild cards, and so I think we all should review the transcript, go back over the exchanges, and see sort of if we can get a better sense of where different justices are coming back on that. Maybe the last thing to say here, and I don't know if y'all talked about refunds in my absence, but I think that's another part of the hypothetical collection, right, is also having the justices think through what that might practically mean, which Justice Barrett seemed interested in more than maybe some of the others. But the last thing I was going to say was I was to some degree reassured by at least some justices' skepticism about what we kind of call Article 2 creep here. But I do think that's something that we need to continue to watch, and so I'm not going to do the crystal ball here, but I think if the really Justice Kagan, I think, led with this early on, and to the extent that other justices get on board with the government's pushing back against the government's Article 2 creep, trying to make this an Article 2 case when it's really an Article 1 case, that to me would be an important step for them to take. So I'm hoping that'll make it into whatever opinion wins the day.
I'll just chime in to say I agree with Kathleen entirely. I mean, Solicitor General Sauer made some strategic decisions that I think turned out to be wrong. In particular, he didn't lead with the two strongest arguments, which came up later. One is the series of hypos, and the other is why. The greater should include the lesser. He mentioned them, but they weren't the focus. But he decided to lead with Dames and Moore in the first instance, thinking it would grab the Chief Justice, who I believe was Rehnquist's clerk.
Not receptive.
And the chief is like, basically, the subtext was, I was there. That was a case for one day only, and it has no precedential impact. Next. And the next thing is, well, this is an area in which the president has significant Article 2 authorities, and there seem to be, maybe Justice Thomas would accept that. Otherwise, no justice thinks the president has Article 2 authorities to issue, at least outside of wartime, tariffs and to regulate foreign commerce. So so that's a dead letter here too. And so those strategies turned out to be not the right strategies, but the justices were doing, I thought, a better job defending the Trump tariffs than the Solicitor General turned out to be.
Well, Peter,
that's what it looks like. That's second. It's after the fact. It's easy for me to say. I didn't have to stand up there and see what the reaction was. He was making predictions about what would resonate and what wouldn't, and I don't think he chose the right things.
Yeah, fair enough. He did sound like he was a little under the weather, so we'll cut him a little slack on that. It's hard to think through a cold and a gravelly voice, even more gravelly than usual. Peter, we'll turn to you for our closing thoughts. Where do you see things coming out a few weeks down the road or months down the road when we finally get an outcome in this case?
Look, I do think I have thought for a while, and I think today's argument reinforced in my mind, it is more likely than not, so above 50%, that the Supreme Court finds AIPA doesn't authorize these tariffs I do wonder a little bit if we'll get, like, I could see an outcome where we frankly get a sort of, a set of concurring opinions that get us to, like, these tariffs aren't authorized, but create some ambiguity about what is authorized going forward. In a way, that's what we got at the Federal Circuit, right? You had 4 judges saying AIPA doesn't authorize any tariffs. You had 3 judges who basically, seem to have the view it doesn't authorize these tariffs, and, like, be interesting and potentially quite confusing if we got, a similar split here. 4 justices saying no tariffs at all, 3 justices saying, not these tariffs, but maybe something else. So we could actually get a fairly muddy decision, about a forward-looking decision, even if it finds these tariffs are unlawful. I hope we don't get that, because I think that would be very muddy and unfortunate, though great for litigators. So I hope we don't get that. I hope we get
here we have an actual disagreement. We have a disagreement. One thing I will.
You think we won't get an unclear decision?
I think the chief will write the majority opinion, and it will have as many justices as he can bring on board on it, and he will write it to get them as many as he can on it. Yes.
But will he be able to do it
Well,
with clarity?
Marty on that, because he knows the Supreme Court much better than I do.
Well, wonderful. Well, this has been an incredibly enlightening conversation. I have really appreciated it. I have learned a lot. I'm sure our listeners and watchers have as well, and not to mention those that will listen to this in a few days when it comes out on a podcast or watch it on YouTube and Substack later. Until then, we are out of time. This has been Lawfare Live. Thank you to Kathleen. Thank you to Marty. Thank you to Peter for joining us. Thank you for everyone in the live audience for joining us as well. Of course, and for those listening and watching at home, if you would like to join us in the live audience for these things, you can, of course, become a Patreon supporter of Lawfare. Go to lawfaremedia.org/support. You can find more information on that.